that are used, and all of you would be aware of it. The one thing which I want to highlight always is that prevention is always better than prosecution. The elephant standing there is always a welcome situation rather than finding the elephant carcass, investigating it, and even taking all measures with good investigation to ensure that the culprits are convicted. Yet, it will not have the same effect as prevention. And therefore, it is important to note, and which you would be aware, that directly population decline is prevented. We have a highly stressed criminal justice system, which you are aware of. You have spent long hours in courts, and you know how many adjournments the defense seeks. So it is quite difficult. And forest departments have multifarious duties. It is not like police, which focuses on investigation. So the time and resources available for investigation are limited, and therefore prevention assumes great importance. You would all be aware of the multi-tiered protection system that most parks, well-protected parks in the country have. Foot patrols, there is no escape from foot patrols. There is a lot of emphasis today on technology, drones, using digital devices, the thermal cameras, infrared cameras, so on and so forth. All that is fine. I am not against technology. But without foot patrolling, parks cannot be protected. I will just give one example. America, with all its technology, failed in Afghanistan. Taliban beat the Americans, who were equipped with all kinds of equipment, because the Taliban had ground knowledge, field knowledge, just like Veerappan. With all the equipment, the STF took so much of time, and so many lives were unfortunately lost. So foot patrolling, mobile patrolling, checkposts, and anti-poaching camps, unless and until anti-poaching camps located at strategic locations, until this protection, multi-tiered protection mechanism is in place and is active 24 hours, it is difficult to protect these areas and prevent hunting. And of course, one other question that crops up is weapons and equipment. Yes, they are important, but I don't think that in the South Indian context, in a very large, in many parks, it is not that you need automatic weapons like what is shown. That photograph is from Nagarjun Sagar Srisailam Tiger Reserve, when we had gone as part of an NTCA team to inspect the capability and whether Naxalism had been eliminated. That's the Greyhounds team along with the Forest Department team there on your right side top photograph. So they are carrying automatic weapons, but in most cases you may not require it. Good leadership plays a vital role in protection systems, because all of you are aware as officers of the social background from which the lower staff are drawn. And you motivate them, you give them leadership, they will do wonders. But without leadership, they will not be able to perform this tough job of law enforcement. So these are some things which you are aware of. And you are also aware of the fact that the illegal trade in wildlife is second only to narcotics. It is estimated by Interpol to be $20 billion. So these people are not going to smile at Gram Sabha resolutions and go away. What it needs is strong law enforcement from uniformed staff and officers, and that is what works. In many NGO fora where I go, people will say, hand over everything to Gram Sabhas, they will protect it. It is like saying, hand over the keys of RBI vaults to taxpayers associations. Will that work? It will not work. So therefore, we need to be very clear that a professional and trained law enforcement agency, currently it is the Forest Department, is entrusted with the task of protection, and that is what will work, for which we need to understand various aspects of the law. So now, with this small introduction, let's go into some key questions. These are practical questions, and you may have answers. Unfortunately, I am not with you today in the same hall where we could have interacted better because of a COVID situation in the family. So I'm addressing you via the Zoom platform. So we will try to make it as interactive as possible. I request the DFO to kindly interrupt me whenever required if there is any specific questions or doubts, and we can sort it out and proceed further. So the first question, which I normally ask in many presentations, what is the difference between hunting and poaching? I know that many of you would probably answer this. This is what has happened, the answers that I've got from across the country, that hunting is only about killing some wild pig or muntjac or some small game. Poaching is about killing of tigers and elephants for tusk and ivory. I think that is what is the perception. However, let me clarify to you that the word poaching is not in the Wildlife Protection Act. You may find a clever defense lawyer if you have used the term poaching in your case documents to question you before the judge or the magistrate and say, my lord, this word poaching is not defined in the act. Then you will have to look into the act, and the magistrate may turn around and ask you this question. So therefore, the term hunting is defined under subsection 16 of section 2 of the Wildlife Protection Act. And that is the term that has to be used in all your case documents, whether it is the wildlife offense report, the Mahajar or Panchnama or whatever you call it, the seizure memo, the search and seizure memo, and your complaint. So that is one thing that I wanted to point out. The second thing, you may often encounter a situation where you find some people inside a sanctuary at a place which is not leading to any village. They may be carrying an empty bag. There may be a roll of wire or cable in the bag. No animal has been killed. No meat is found in the bag. Under which sections of the law will you prosecute? You will say that it is trespass, correct? Now, would you only apply offense of 27 or would you go further? If you read subsection 2 of, subsection 16 of 2, section 2, hunting, the definition of hunting, which I'm going to read out a little later, includes every attempt to do so. So physically an animal may not be killed. There may be no tusk, no horn, no antler in that bag or meat, but you can book a case under section 9 also for hunting, because that group of people or gang had no business to be inside the sanctuary. It is not a simple case of trespass. But there could be cases where you may find a group of people inside the sanctuary. This is the discretion of the officer leading the patrol party. If circumstances show that they were suspiciously moving around with an attempt or intention to hunt or lay a snare or lay a jaw trap, then you have to invoke section 9 and book them for hunting, even though you have not found anything inside in the bag. So this is one thing that I want to clarify. Next, normally there is some confusion between bailable and non-bailable. If you read subsection 1 of 50 and subsection 3 of 50, both empower forest officers to arrest without a warrant. Am I correct? Many of you have used this. But you read the sections carefully. 51 is, the wording of 51 and 53 is a little different. In 51, which applies to hunting, trade, animal article, trophies, etc., it becomes a non-bailable offense. Whereas under 53, if you find somebody has trespassed into the forest and is not indulging in any other act, it becomes a bailable offense because the offense carries a imprisonment term up to 3 years or fine or both. Whereas in case of hunting, it is a minimum imprisonment of 3 years, which can extend to 7 years. So this is another thing that I wanted to bring to your notice. Minor forest produce or non-timber forest produce. Often, there is some confusion on this. For example, somebody has collected gooseberry, or somebody has collected grass, or somebody has collected some other forest produce. There is no definition of forest produce in the Wildlife Protection Act. However, if you read 12B, subsection 12B of section 2, it says that the definition contained in the Indian Forest Act is the same definition which applies under the Wildlife Protection Act. Therefore, you need to read both the laws, because suddenly in court, the magistrate may ask, what is forest produce? Please show me the definition. You will search the act and you will find that there is no definition. So therefore, if you kindly focus and see the read definition of given under 12B, subsection 12B of 2, you will find that they have referred it to the Indian Forest Act. So therefore, these are some small little details that I want to bring to your notice. Many of you may know all these things. I'm not saying you may not know, but it would be good to debate these things. Then, this is very, very important. I have heard, and I could be wrong, please correct me if I'm wrong, that offences of Schedule 3 and 4 species are being compounded in Tamil Nadu in some areas. If this is being done, please do not do it, because all offences, hunting offences in a sanctuary, whether it is Schedule 1 or Schedule 4 or any of the schedules, carry a minimum imprisonment of 3 years, which can extend to 7 years, and with fine. 54 of the Act very clearly says no offense for which a minimum period of imprisonment is prescribed can be compounded. Therefore, please take note of this. Please do not compound it. You will have to compulsorily prosecute the offender. Compounding is not allowed and it would be illegal. Often we find there are people who misbehave when they enter the sanctuary. They will be sitting on the side of a public road, passing through the sanctuary. Some people may even light a fire and start cooking. They may open their baskets and start eating and so forth, throw some food at monkeys or something else and tease the animals. So they are causing disturbance. How another section is subsection 4 of 27. If you read that, it says nobody shall tease or molest or disturb wild animals in a sanctuary. So that is one thing. There is another thing which can be used, and there's another offense, similar offense of tourist vehicles disturbing wildlife in a sanctuary. Now for both these, subsection 4 of 27 will apply. But there's another important thing which you can use, which is the Chief Wildlife Warden or the Wildlife Warden can pass an order under 51, subsection 1 of 51. This is a little known fact, and I will read the particular section, which is important because it says it's in the penalty section, and it says any person who contravenes any provision of this act or any rule or order made thereunder. So if or commits any breach of any conditions. So therefore, if an order has been passed whereby it is posted, the order is also put up on a board on the entrance to the sanctuary at the checkpost, then what happens is you can book them for a violation of the act. So this is another thing that I wanted to bring to your notice. Then there is some confusion regarding the terms arrest and detention. Some of you may know it, but detention is temporary. Arrest is a formal act that you perform when you say or put a person under arrest. The moment you put a person under arrest, you can detain a person, question the person, and if you find that his answers are valid and you are satisfied that the person is not indulging in any mischief or hunting or whatever, you will release the person. But the moment you find that there is evidence and the person caught has been indulging in violations of the law, then you will put such person under arrest. And the moment you put the person under arrest, all the procedures that have to be done in terms of producing the person before the magistrate, the right of the person to be his near and dear or somebody being informed, his right to a legal help, etc., have to be defined. At the end, I'm going to show you the D.K. Basu judgment and the guidelines with respect to arrest, which will be very useful. We come to another important question. In most cases, see, let me put it very, very clearly and bluntly. There is no system or procedure of FIR and charge sheet in the Wildlife Protection Act. This may confuse some of you because in many states, they use some of the provisions of the State Forest Act, which may have this provision of FIR and charge sheet. But you are trying to seek a conviction or trying to book a person under the provisions of the Wildlife Protection Act, which is to be implemented along with provisions of the CRPC. So therefore, it is very, very clear that you will have to adopt a different procedure to book cases under the Wildlife Protection Act. So the moment you detect an offense, it is called as Wildlife Offense Report, WLOR. In some states, it's called as POR, Preliminary Offense Report, etc. But it can't be an FIR under 154 of CRPC. The police can do it, but not the Forest Department. And the Wildlife Crime Control Bureau has brought out a manual. Even in that manual, you will kindly see that, in fact, I have highlighted this in my book. Also, the format is also there. They have prescribed a format, and under subsection 4 of section 50, the wildlife of and proceed to investigate, because these are cognizable offenses of hunting. You will proceed to investigate. Of course, you will produce the person before the magistrate within 24 hours, excluding the time of journey. You will also produce the search and seizure memo along with that. You will produce, I don't know if case diaries are being written and adopted in Tamil Nadu. Are they being done? Case diaries? I'm not able to hear. So anyway, if it is being done, that is very good, because one thing about a case diary is that it is a fantastic document which will not be available to the defense. No magistrate can order you to hand over a copy of your case diary to the defense or the accused. So you can write and record certain things which will help even somebody who takes over the investigation or the trial of the case when you are transferred. So therefore, case diary is very important. You will produce all this before the magistrate, and you can also seek a remand of the person. We'll go through all these provisions in detail. And at the end of the investigation, you have to compulsorily file what is called as a complaint. And the difference between complaint and charge sheet, I will explain. Normally, charge sheet, there is no term charge sheet in the CRPC. The term used in section 173 of CRPC is called as a police report. So I will walk you through the various provisions in a clear-cut chart, which will make it very clear to you. So please, all these offences under the Wildlife Act are complaint cases, and a complaint to the magistrate is preferred under 55B of the Wildlife Protection Act. I'm sure officers are authorized in Tamil Nadu by way of a government order to file complaints, and the rank of the officers and so forth. Now again, in terms of terminology, just like the first one I showed you about hunting and poaching, the term raid is used. There is no term called raid. It is always called as a search. And search, there are two situations when you search, correct? One is a vehicle which comes into a checkpost. A uniformed officer, we can search the vehicle to find out if any weapons or any illicit produce is in the vehicle. Or you get specific information and you go and search a house in a village or wherever. Now, in case of a search that you carry out at a checkpost, you do not obviously need a search warrant. But when you are going to search a premises in some village based on some information, you will need a search warrant, and under 50 subsection 8 of the Wildlife Protection Act, an officer of the rank of ACF is empowered to issue such a search warrant. It is not the ranger who issues the search warrant, because there is some confusion and so forth, because state forest acts, I am aware, do empower rangers to issue search warrants. And there is also a misconception in some states that I am empowered under the law, why do I need a search warrant? No, these are again procedural defects that will be pointed out by the defense. And even if you find contraband in that house, the search may be vitiated, or it may be held as procedurally faulty. So when the law provides for it, it is always better to go with a search warrant. Now, after these questions, I have broken up the act into 4 parts. There are several prohibitions, as you are aware, which you are using day in and day out. There are powers that you have, which you are aware of. There are procedures, even under the Wildlife Protection Act, and I will tell you where the procedure of the Wildlife Act prevails and where the procedure prescribed under CRPC will apply. This, the Supreme Court, in a very major judgment called Motilal versus Central Bureau of Investigation and others, has held very clearly, and that applies. Then there are penalties. Now let us go into some detail of the Act. Any questions till now? I can answer in case somebody has any questions. You will have to unmute the mic, and because otherwise I can't hear you. If there are any questions up to this point, I can take those questions. Kindly unmute the mic.
Can you hear me, Praveen?
Yeah, it is audible now.
Yeah, Praveen, this is Sanjeev here.
Yes, Sanjeev.
Nice to see you after a long time.
Yeah.
And there was a little bit of drop in the line at a couple of points.
Okay.
The previous slide. So
Which one? I can go back to that.
Yeah, I can just ask if you want to go back. You can ask me to go back and read.
Yeah, I've gone to the previous slide, Sanjeev.
Yeah, that was at FIR and wildlife offense report. Yeah, and the next point, complaint or charge sheet.
Okay, what I was trying to convey, Sanjeev, is as follows. that the Wildlife Protection Act does not have a procedure of FIR and charge sheet. These are what are called as complaint cases. As officers would be aware, there are several special acts under in India. It includes acts not only like the Wildlife Protection Act, Forest Act, Excise Act, so on and so forth. So in such cases, the procedure prescribed for prosecution is called as a complaint, or these are called as complaint cases. The police have the power under section 173 CRPC to file what is referred to commonly as charge sheet, but it is, the legal term is a police report. That is available under the Wildlife Act. Neither is the FIR registered by the police under 154 CRPC. That is also not applicable. So the Wildlife Crime Control Bureau has prescribed that the officers will register what is called as a wildlife offense report, which is kind of equivalent to an FIR on detection offenses. This is done under section 4 of section 50 of the Wildlife Protection Act. It is mentioned in my book, and it is also in the Wildlife Crime Control Bureau investigation manual. So this officers can refer. And after completion of the investigation, a complaint to the magistrate under 55B of the Wildlife Protection Act has to be filed, along with all the evidence, documents, ballistic report, or the report. And then the magistrate will take cognizance of the offense under 191 of CRPC. I've got a chart, Sanjeev, which I'll present to you. So this is the point that it is a wildlife offense report followed by a not FIR. So this is what I. So
yeah, this is Dr. Shivaganesh Bhagwa. I heard about you. I never met you. I have one information which I want to just share with you. When I was working with the DNHS, what you said was exactly correct in terms of field intimacy. Unless you walk in the forest on foot, patrolling, whatever technology you use, and drone and whatever now the trap and alarming system, and those give only the scientific inputs only. Unless you patrol in the forest and gather information regarding the secrecy behind, suppose if the elephant die, because you focus on two species, one is a tiger and another is elephant. In the case of right now, just now what happened in Coimbatore, there are a lot of series of elephants died, and information what they could not able to collect in the field. It could have collected all the variables, reasons behind the death of elephants. Prosecution will be very, very easy. But there it comes of patrolling on foot. And I am very sorry to say that in the present scenario, that kind of a trend is not much there. That field intimacy by walking in the jungle, work together and see that how the system, how the ecosystem, or how the behavior of animals, all those things there, whatever laws and enforcement law, you just put it before us is an excellent thing. But you go to the court, it doesn't work it out because that field intimacy, the patrolling on foot is not much there right now. This is my suggestion.
Okay, thank you. So let us proceed because we already at 12 o'clock, 12:10. So we are short of time because I have a lot of material to present. Now the notification which I mentioned, Karnataka has issued such a notification under the Wildlife Protection Act for each, wherever the term, the post is mentioned as Chief Wildlife Warden or authorized officer. So that authorized officer of what rank has to be specified by the government. For example, if you see 55B on complaints, all foresters of and above the rank of forester, all police officers of and above the rank of sub-inspector. So this kind of a notification is required, and I think Tamil Nadu would have issued such a notification. If not, it would be good that the DFO and the conservator and others take it up appropriately with the Chief Wildlife Warden. Now, there are other differences in terminology which I want to bring to your notice. What is the difference between a wild animal and a captive animal? Wild animal is all those species listed in Schedule 1 to Schedule 4 and found in the wild. However, any of these wild animals, if it is held captive or in captivity or captured, then it becomes a captive animal, and captive animal is defined under subsection 5 of section 2 of the Wildlife Protection Act, whereas wild animal is defined under subsection 36 of section 2. Wild animal and wildlife, these are all terms which can confuse. Wild animal, as I said, is Schedule 1 to 4. Wildlife includes land, vegetation, etc. Wildlife is defined in subsection 37 of section 2. This I am pretty certain many may not know. Wild animal and scheduled animal. Scheduled animal is defined under 49A clause A of the Act, and this involves scheduled animal means any species listed in Schedule 1 or Part 2 of Schedule 2. This is a chapter related to trade and commerce in wild animals. So therefore, these are terms which you should be familiar with, and you should use it in your case documents. Animal article and scheduled animal article. Again, scheduled animal article under 49A clause B defines that these are animal articles made from species listed in Schedule 1 and Part 2 of Schedule 2. Animal article includes everything. This is defined under subsection 2 of section 2. I know I am going a little fast because there's a lot of material. Hunting and poaching, we have discussed. Trophy and uncured trophy. Trophy is something where a skin has been processed. It has been subjected to taxidermy. Whereas, what is an uncured trophy? We normally refer to a dead, freshly killed animal as carcass. It is not carcass as per law. It is an uncured trophy. For example, a dead sambar you find and you try to book a case. You will say, I found a case of, a carcass of a sambar which has been freshly killed. No, please use the term uncured trophy. This is defined under subsection 32 of section 2. 31 is trophy, 32 is uncured trophy. What is the difference between national park and sanctuary? This also, in many cases, there is some confusion. I will quickly explain to you there are three fundamental differences between a national park and a sanctuary. The first difference is, during the notification process, in a sanctuary, the collector, in consultation with the Chief Wildlife Warden, can allow the continuation of certain rights within a sanctuary. But in a national park, it cannot be done. This is the first difference. The second difference which you would be aware is that in a national park, there is a complete prohibition on livestock grazing. Whereas in a sanctuary, the Chief Wildlife Warden can assign a certain portion of the sanctuary where livestock can be grazed subject to the condition that it is immunized. The third difference, which again is not known very widely, is that a sanctuary can be upgraded to a national park. A national park can't be downgraded to a sanctuary. Other than these three differences, the law applies evenly to national parks and sanctuaries. And if you read the Act, in case of a very important section 29, which says no destruction in a sanctuary, 29 applies to a sanctuary, 35(6) applies to a national park. The wordings are exactly the same. So you can take a look at this. Let's look at some definitions. I have already told you about animal article. We have discussed about hunting, and every attempt to do so, you must clearly tell the magistrate if you have caught somebody in the act of hunting, but they've actually not hunted. So you must point out this definition, and I'm pretty certain courts will take cognizance. And it is such a comprehensive definition, as you're aware, that it includes everything. Trophy we talked of. The definitions are available in the Act. It is in my book. You can refer to it. Uncured trophy we discussed. It includes a freshly killed animal. Weapon, you would be aware, and I would like to point out that it includes not just firearms, but it includes everything, including snares, traps, and any instrument capable of killing an animal. So therefore, the definitions are wide, and that is why this law is a prohibitive law or a restrictive law. Whereas the Forest Rights Act, which we are all facing problems with, is a enabling law or a beneficial legislation. You say you can do this, you can give this, they can also do this, etc. But Wildlife Act says you can't do this, you can't, this is prohibited, etc., etc. Wild animal we discussed, wildlife we discussed, scheduled animal also we discussed. Now let us look at the important prohibitions contained in the law. You're all aware of section 9, that it is a very clear, simple, straightforward section. No gray areas. No person can hunt any wild animal listed in schedule 1 to 4. I do not want to go into the details of how the chief wildlife warden can permit hunting in case of research and so forth, because that is not required for this presentation. 27 contains a clear-cut prohibition on entry or defacing the boundary line. And if you read the wordings, it also takes links to the IPC, wrongful gain. Somebody may wrongfully gain by occupying a portion of the sanctuary. So that term is also used. Even in my book, I have provided these details. And I told you about 27.4 about littering, like people sitting and trying to cook along the public road in a sanctuary. 29 is very hugely important. This is mostly with respect to the other side of the Wildlife Protection Act, which is about trying to defend habitats. So 35, 6 and 29 are exactly same. And this no destruction unless such destruction is for the improvement and better management of wildlife. For example, tomorrow you will have some project coming into your area. You will have to justify as to how that destruction is for the benefit of wildlife. Anyway, that's a separate subject which I don't want to go into today, and it's not essential for today's discussion. You will all know that section 30 is a specific section on causing of fire, which is an offense. And unfortunately, very few people have been actually prosecuted and convicted for causing fire. So much of forest fires is affecting our sanctuaries and national parks across the country. But unlike hunting, where a lot of cases have been filed, a lot of offenses have been filed, people have been convicted, in case of fire, there is hardly any prosecution or conviction. 31 is hugely important, because whenever you find somebody who has entered the sanctuary with a weapon, or for example, dynamite in case of fishing in the riverside, or any other injurious substance, all of you are experienced officers, you are aware of how pesticides are used to poison kills. So these are all will come under offenses under 31 or 32. These are clear-cut violations, and there's a clear-cut prohibition on all these things inside a sanctuary. Grazing we talked about. it can be permitted in a sanctuary, but the chief wildlife warden can also decline to allow grazing in a sanctuary. It is not as if it is to be permitted. It is not a matter of right. And sometimes when sanctuaries are notified, typically what you do, 3 or 4 reserved forests are amalgamated and notified as a sanctuary. And let me add one point. There is no necessity, if you are including only reserve forests while notifying a sanctuary, to go through provisions of 19 to 26. A final notification under 26A can straight away be issued if the area that is taken up for the sanctuary comprises only of reserved forests. However, the rights that are recorded in the reserve forest notification, whether it's the rights to grazing or right of way, etc., will continue till it is settled. So this is the law. One hugely important thing which is not happening around sanctuaries and national parks is the process of registration of arms. Under 34, any person who resides within 10 kilometers of a sanctuary or national park must, even if he holds a license under the Arms Act, must register the weapons with the Forest Department. And in Karnataka, the authorized officer for this is an officer of the rank of ACF. So this must be done. A notification has to be issued. And please, if you have not implemented this around Kaveri North, please try and implement this. This will be hugely important because you will know who are the weapons arms holders. And when somebody applies for a license, without the concurrence of the chief wildlife warden, the collector cannot issue an arms license. And once the application comes to the chief wildlife warden, it is sent down, the DFO will get it, and it will be verified if the person is a bona fide person and he is not involved in wildlife offenses. So these are important. Registration of arms. You can have a register at every range level of who are the people within 10 kilometers who have weapons. This is important. Livestock grazing we talked about. 39 is another highly restrictive section of the law, which is about every animal, wild animal, being government property. So nobody can be in possession of such government property. And if they come into possession of such government property, within 48 hours, they have to report to the authorized officer. It could be the range forest officer of the area or the nearest police station. And let me point out that the Wildlife Act has concurrent jurisdiction for both police and forest with respect to prosecution of offenders. The police may not have powers under the Act to manage national parks and sanctuaries, but they certainly have full powers to take up forest offense cases, wildlife offense cases, and prosecute people. So it has concurrent jurisdiction, and that is why the nearest police station is also empowered to receive information about the possession of government property. And 39(3) puts a restriction that nobody without a permit can acquire, keep, or sell such government property. This is a very, very tight section, and anybody you find dealing in trade offenses will, obviously the chief wildlife warden would have not given permission, and that becomes an offense under 39(3). And there are several other sections under 42 and 2A. No person can sell, buy, or transport. 48A also has restrictions on sale. 44 and 49B, again like 29 and 35(6), are exactly worded almost similarly, but 49B applies to Schedule 1 and Part 2 of Schedule 2, and 44 applies to other schedules. So you can, and in this, dealings in trophies, taxidermy, meat, antlers, etc. is prohibited. 48A, hugely important. You may find a case, for example, at one of your checkposts, a Tempo or a Tata Ace or whatever vehicle comes, or a taxi, you search the vehicle. You find that there is some wild animal article in the vehicle. The driver will plead before you saying, "Sir, I did not know, sir. Somebody gave me this parcel. I am just taking it. I am innocent." You will, of course, as experienced officer, interrogate him. And if you get a genuine form and opinion that indeed that driver was unaware of what he was transporting, what you could do is you could include him as a star witness. Instead of making him an accused, you can make him a star witness and an eyewitness saying that XYZ gave him the parcel, but he did not open the parcel. In good faith, he accepted the parcel and loaded it into his vehicle, and that parcel contained animal articles or trophies. And therefore, he can be a very good witness to prosecute the real offenders. So that is something which at field level, you will make those decisions, and in your discretion, what you find correct, you will proceed with. Now, this I mentioned to you earlier, breach of any order or condition, 51(1). So you can, depending on the nature of offenses in your sanctuary, if a specific offense has not been highlighted or it doesn't correspond to a particular section, you can get the Chief Wildlife Warden to issue an order stating that that activity amounts to violation of the law. Because you would be aware that under 33, the Chief Wildlife Warden is the authority who must ensure security of wild animals. So if the act can threaten the security of wild animal, an order can be passed. Even if challenged in court, it will be sustained. There is a prohibition on abatement. You are aware of this, and this section will have to be invoked because the real offender will be sitting somewhere in some town. The person you catch will be some small fry, but he will, in his statement before you, say that no, XYZ is actually gave me 500 rupees or 5,000 rupees to trap this animal. So you will have to include 52. You will be aware of this. Then there is a complete chapter on forfeiture of property derived from illegal trade. I am not going to go into this because the statutory authorities for that have not been constituted in many states. And this is similar to the Prevention of Money Laundering Act. So let's keep that for another day. Let us look at powers and procedures. Under 34A, any officer of the rank of ACF has been empowered to remove unauthorized structures. But please remember, there is a procedure embedded under 34A. You can't just go and unilaterally evict, clear the encroachment. You will have to issue a notice, provide 30 days time to the person to prove before the DCF whether he is in possession of the land legally, and only based on an order passed by the DCF after due hearing can you go and remove and clear the encroachment. Please do not go unilaterally and clear it. I know of the problems that forest officers face when they go for encroachment clearance. I know of situations where when combined team of forest revenue and police have gone, only forest people have been slapped with atrocity cases. So these are common things. So as far as possible, follow the procedures, and you will have to implement, check if the Forest Rights Act, under the Forest Rights Act. And let me share with you that our organization is the lead organization which has been fighting against the Forest Rights Act since 2008. And the matter is poised at a crucial stage now before the Supreme Court of India. On 13th of February 2019, a major order was passed saying that all rejected claims must be evicted. However, being an election year, there was a big hue and cry, and that is under the more time has been given to states, and Forest Survey of India has given a report that 71% of the rejected claims are bogus. So all this will be considered by the Supreme Court. So please don't feel bad that right in front of you people are occupying. We will get some result in this Forest Rights Act case. Unfortunately, due to COVID, it is held up, but it will be taken up. Now, every wild animal hunted shall be government property. This I explained. This is under powers. And let me point out this very important thing which Supreme Court has concluded in Madhukar Rao versus State of Madhya Pradesh, that the seized vehicle will become government property only after the person has been convicted. Now you will ask this question, no, we are seizing the vehicle and confiscating it. The word confiscation is different from seizure. Confiscation or forfeiture is permanent, seizure is temporary. Now, if you want to seize that vehicle, most state forest acts prescribe a separate procedure, and it empowers officers to seize the vehicle, not release it on a bond, and take it over as confiscate. The confiscation proceedings are also, procedure has been prescribed. I'm sure Tamil Nadu Forest Act has it. So the best way to do it is, when you are seizing a vehicle, try to do it under the Tamil Nadu Forest Act, because under the Wildlife Protection Act, without the person being convicted, you can't confiscate the vehicle. You can seize the vehicle, you cannot convict it. And a magistrate gets control over the vehicle, because under 54, it clearly says any person arrested or things seized shall forthwith be taken before a magistrate. So you will not have control, or the authorized officer will not have control over the seized vehicle. The magistrate can order the release of the vehicle, whereas this provision may not be available under the State Forest Act. So this is the small little text of the Supreme Court, and they upheld a full bench judgment of the Madhya Pradesh High Court. I can't go into the details of this. I'm just bringing it to your notice. Those interested can download the judgment. It is also, the references in my book. There are other powers that you have, which you are aware of. Subsection 1 of 50 very clearly states, and you would have observed one thing, certain sections start with the words notwithstanding anything contained in any other law for the time being in force. What does this mean? It simply, these are called as non-obstant clauses, which means that notwithstanding anything contained in the State Forest Act or the CRPC, any forest officer or police officer not below the rank of sub-inspector is vested with the power of entry, so on, so on, so. The Supreme Court, in a very major judgment in Motilal versus Central Bureau of Investigation, which I mentioned earlier, clearly said that police officers are also empowered to act, investigate, and arrest persons, seize wildlife articles, and book a case for wildlife offenses. So this is very, very clear. Now, 51 and 53, I did explain to you about the difference in the power to arrest without a warrant. 54 we talked of, and I also told you about the wildlife offense report. I'm showing you a order, major order of the Karnataka High Court, which has clearly held that in conventional crimes, investigation starts with registration of FIR. However, in wildlife cases, the seizure takes place before the registration of a case. So in different states, it's called so-and-so. And then it goes on to say that in order to avoid technical problems, the wildlife cases may be named as wildlife offense report. The wildlife offense report should be prepared under 54 of the Act, and it is clarified that in part 2 of Schedule 1 of CRPC, any offence under any special law which carries 3 years and above, as in the case of Wildlife Act, will be a cognizable offence, which means that you can arrest without a warrant, you can investigate the case without permission from the magistrate, and at the end of the investigation, you can file a complaint. So this is what the court order has held. There's another important order in Deepak Mahajan, which the Supreme Court held, that forest officers can also seek remand. It is not that when you arrest a person, the person just goes to judicial custody or is released on bail. See, it is very important to secure the person because further seizures may be required. You may have to recover some more material. And as you are aware, under subsection 9 of 50, any material or evidence gathered in the presence of the accused is admissible in a further trial. So he cannot deny it. So therefore, even if the person has been remanded to judicial custody, kindly you can move a memo before the magistrate and seek the person for 12 hours from 6 a.m. to 6 p.m. Take the person to the spot, recover the material and send him back and hand him over to the jailer at the sub jail before 6 p.m. And if required and you find that they are troublesome people, you can also get a medical done before handing him. So therefore, these are things that you have the power to seek a forest remand. But then the question arises, do you have a lockup? In most forest ranges, there is no lockup. And I was in Tamil Nadu and I was talking to officers of North Kaveri in 2012, and some very experienced ACFs were there. And they told me that they ran into some problem because somebody attempted suicide. So these are problems. So lockups have to be as per the design. The police manual will have the design, and you could have these, because if you are taking somebody into custody, it is a very big responsibility. And I'm pretty certain somebody in the room would have faced some problems also. So therefore, take all the precautions before exercising these powers. Another hugely important aspect which I want to bring to your notice, and I want to ask this question. Who is investigating wildlife cases in Tamil Nadu? Is it the ranger or the ACF? Can it be clarified very quickly? Sorry?
Range officer is the responsible.
Okay. Now, I want to point out to you very clearly, please do not follow this procedure, because subsection 8 of 50, kindly read it. Again, as I pointed out, it starts notwithstanding anything contained in any other law. I know that Tamil Nadu Forest Act may empower us to investigate, but because of this clause, it becomes absolutely necessary that officer of and above the rank of ACF alone can investigate. And if any defense lawyer points this out, as I told you earlier, it is a fatal procedural defect. The case will be dismissed right there. And this has happened. I had a major discussion I did a program for Assam Forest Department and Assam Legal Services Authority. And there was a sitting High Court judge, very senior judge also. And this was debated in very great detail. And there is a very major judgment of the Supreme Court and Bombay High Court also. See, the detecting officer cannot be the investigating officer for the simple reason that the Constitution of India provides for a fair trial to any accused person. And Supreme Court has clarified that fair trial includes fair investigation. So the detecting or arresting officer cannot be the investigating officer. Please be very, very clear about this. There is absolutely no confusion. This has been tested in the highest court of the country, and the Supreme Court has pointed out that this is particularly important where there is a reverse burden of proof in laws. Wildlife Act, as you know, and I'm going to come to section 57, has a reverse burden of proof. If you prove prima facie before the magistrate that a person was found with animal articles or trophies, and the magistrate accepts it, the burden of proof shifts. The accused will have to establish to the satisfaction of the court that he is innocent. The prosecution need not establish that that person is guilty. So therefore, it becomes further relevant that in case where reverse burden of proof in such laws, the investigating officer is different from the detecting officer, because you are going to receive and record evidence, and that cannot be done by the person who affected or detected the case and affected the arrest and so forth. So this is very important. And these are the case laws with respect. And another, in Ajmer Singh, it is now on your screen. At all times, you can't find independent witnesses. This is really the case with respect to wildlife cases. And if you really try to show independent witnesses by just trying to create something, you will be caught again. The defense lawyer will say, my lord, your honor, how can a person at 12 midnight, how can two independent panchas or witnesses be taken in deep in the forest? Then again, the magistrate will suspect your story. So within your staff, one or two people can become the witnesses. But when the officer selects the person, please select the right person who will, when subjected to cross-examination or in the box, doesn't start shaking. Because the moment somebody is put in the box, a lot of things happen to a lot of people. Some of you would be aware of it. Unfortunately, I'm not there. I cannot see the reactions on your face, but I know these are difficult things. So you need not have an independent witness. For example, if you are searching a premises based on prior information, it is always better to have two independent witnesses. But right in the middle of the forest, at night you are on mobile patrolling and you catch somebody, obviously there can't be independent witnesses. So these are things which have been clarified by the court. And the other judgment which I have shown, 2015 3 Bomb CR, is the Bombay High Court judgment, where a case was dismissed in Goa, in Netravali Sanctuary, where the ranger had investigated. And the defense pointed this out. And I told you about 59, evidence will be recorded, admissible if recorded in the presence of the accused. I mentioned about compounding. 54 clearly states no hunting or encroachment case in a sanctuary can be compounded. So please do not compound. If you are following that system, you will have to review it and change. And compulsorily it has to be prosecuted. 55B, I talked of that the cognizance can be taken by the magistrate only on the basis of a complaint. This the Supreme Court in Murad Ali Khan has very clearly held. There could also be another situation. When you catch somebody, he has an illegal weapon. Often the case, he is also hunted. So there are two cases now. A case under the Arms Act and a case under the Wildlife Protection Act. Now you can take up the case under the Wildlife Protection Act, as we discussed, 31, entry into sanctuary with weapon, and hunting under Section 9 and other related sections. You are fully empowered to do it. But Arms Act violations, you do not have jurisdiction. So the police will have to investigate. So what happens in these cases is the police will register an FIR for the Arms Act violation, and they will investigate and file a police report. You will investigate the wildlife offense and file a complaint under 55. Both cases will be heard together in one common trial, and there will be one conviction that the magistrate can do. Punishment cannot be granted twice for the same offense. So this is the law. It is called as double jeopardy. So this is not allowed under our constitution. So therefore, both cases do not lose their identity. So both can be pursued. I know I'm trying to go fast because of lack of time. 57, there is a, as I told you, burden of proof lies on the accused. There is a good judgment called Sansar versus State in Delhi High Court, and it says that once prima facie it is accepted that the petitioner was in conscious possession of trophies, etc., he has to, the presumption is that he is guilty unless he disproves the same. This is very, very clear. Now, 61 says power to alter schedules, it lies with the center. State and center both have rule-making power under certain subjects. Let us now spend the next 10 minutes clearly on this. Many of you may have confusions. I'm pretty certain, and these charts are also in my book, so you can go through it later. From detection to cognizance, what are the different steps involved and the relevant sections of the Wildlife Act and CRPC. A detection of an offense and seizure happens under 51. Next, what you do, you draw a panchnama or a crime scene inspection memo or a mahajar or whatever you call it. Next, you prepare a search and seizure memo. You will make a list. You will affix marks on the property seized. You will seal the property and it will also have to go to the veterinary inspection and so forth. And you will detain a person or effect an arrest under 51 or 53 without a warrant. You will prepare an arrest memo. You will follow the guidelines contained in the DK Basu judgment, which we'll look at if we have time. That is information to the relative. You will get a medical done, and you take all precautions to ensure that the person is kept properly. Otherwise, all kinds of allegations will crop up, as you are aware of, and that will be difficult to handle. And you will, in case of a hunting in a sanctuary, as I said, it becomes a cognizable, non-bailable offense. So you will not grant bail, and you will produce the person under section 54. You will also register a wildlife offense report in the format. You will make an entry in the offense register, and you will produce all this before the magistrate within 24 hours. And as I said, if you are doing the case diary, it will be very good. You will also get a medical done of the offender and a veterinary report to establish that this is sambar or whatever that wildlife article is. Two things will happen. The person can be remanded to forest custody. You can seek forest custody, as I mentioned, or the person will go to judicial custody up to 60 days if investigation extend beyond 24 hours, or the person can be granted bail by the magistrate. So under 437 of the CRPC, read with 51A. See, 51A of the Wildlife Act clearly says a person who has been previously convicted of an offense cannot be released on bail till the public prosecutor is heard. You are aware of this. So, but if you don't produce material before the magistrate to show that the person is a history sheeter, or at least you have to establish that he is a repeat offender. He may not have been convicted. Even then, it is the discretion of the magistrate to not to grant bail. And I will tell you what are the circumstances under which bail can be denied. I will explain that to you very quickly. Then you start the investigation. It is done under 58. Officer, as I said, only above the rank of ACF or above. And this has to be completed within 6 months, preferably at the earliest. And if it gets delayed, you will have to seek justification and make an application to the magistrate seeking more time. This is prescribed under 167, 5 and 6 of CRPC. That is why I said importance of understanding CRPC. You will record evidence in the presence of the accused person, and this will be admissible in a further trial, and you can seek custody within 14 days. And also, if the accused is required to collect evidence, say between 6 a.m. and 6 p.m. or whatever. Then once you have completed this stage, you will prepare a complaint to the magistrate under 55B, also read with CRPC 2D. A complaint is different from a police report. So that is how complaint. And the format of complaint is in my book. It is also based on the same format that WCCB has prescribed. And you will also show whether the status of the accused, that is in custody or on bail or absconding, or you may have preferred not to arrest the accused. That has to be informed, and all complete evidence, material objects, duly numbered documents, witness statements, DNA, ballistic, etc. Everything has to be filed along with the complaint. You can't file it later. So please ensure that everything is filed together. The magistrate can take cognizance at this stage if you have prepared a proper case, a valid case. He will take cognizance under 191A of the CRPC or dismiss your complaint under 203 of CRPC. Now, if the magistrate takes cognizance, what are the next steps? Cognizance to conviction. Now, cognizance has been taken, and any offense which carries 3 to 7 years is called as a warrant case. The CRPC prescribes a separate procedure for warrant cases initiated otherwise than on a police report. In other words, it is initiated based on a complaint under the Wildlife Protection Act. Here what happens? The magistrate has taken cognizance. The next step, a warrant or maybe even a summons can be issued under 204 of CRPC, and provided the process fee has been paid, witness list has been filed. It will be done only after that. So these are small little steps. Some of you may be aware of all these things. Then the prosecution is given the opportunity to present pre-charge evidence. This happens under 244 of CRPC. And this is applicable to warrant cases initiated, as I said, on a complaint filed by a forest officer. If the magistrate, after considering the evidence that you have presented, he has the power to discharge the accused and conclude that no case is made out. This, the 245 of CRPC gives him power. Or he proceeds to frame charges. Charge sheet is different from framing of charge. Framing of charge is that stage of judicial cognizance where a judge or a magistrate prima facie accepts that a person has to go to trial. So charges are framed, specific charge of hunting or carrying of weapons, etc. are framed. This is a very, very important stage. Here, the accused can plead not guilty guilty, and there is an opportunity for him to examine your witnesses. Your witnesses are called as prosecution witnesses. These are under the following sections of CRPC. Or the accused pleads guilty and it will lead to a conviction. Both can happen. What happens next? If the accused pleads not guilty, the accused is examined and the magistrate will give an opportunity to explain the incriminating material that the prosecution has gathered against him. He will also produce his own witnesses. For example, you will say that Muniswamy has been caught at Palar at 1 o'clock in the afternoon. That is your accusation. Deep inside the forest with the tusk. He will produce a hotel bearer in Satyamangalam and say that he was present in my hotel and I served him lunch at exactly same time. So you are aware of all these things. So he will present his own evidence and accuse, or he will produce a CCTV footage from the hotel and say, Your Honor, I was present in this hotel. How can I be at the crime spot? So these are all things which will happen. Then what happens? If the magistrate convicts the person, there is another stage in warrant cases where after conviction, the defense is given an opportunity to argue for a milder sentence. And after hearing the accused, the magistrate will convict the person and sentence the person. Or if he has not done that, he will acquit based on defense evidence and so forth. So this is the procedure in case of warrant cases. In a simpler case of trespass and so forth, it is called as a summons case. How does this work? Many stages which we saw in the other process is not available here. This is a simpler process. After magistrate has taken cognizance, there is a limitation period. If the offense carries up to 3 years, beyond 3 years, you cannot file a complaint. The summons is issued under 204. The accused appears. The statement or substance of the statement of offense is presented, and the magistrate will ask the person whether he pleads guilty to that offense or not. If he says he wants to, if he pleads guilty, he straight away can be convicted under 252 of CRPC. Or if he pleads not guilty, prosecution will then present evidence under 254. Then the accused is examined. This process is there, but as you would see, there is no framing of charge. That's a very important stage which is missing here. And then the defense can produce his evidence like in the other one, and there is a conviction or acquittal, and he can pass a sentence without hearing the accused. Quantum of sentence can be decided by the magistrate alone. The accused will not have an opportunity to seek a milder sentence. So these are the procedural aspects. We are at 1 o'clock now. I have a few more slides. Can we extend it by 10 minutes? I'll try to conclude. Okay. Can I go ahead? Can I go ahead, please?
Yes.
Okay. Okay. 10 minutes. I'll try to finish. Okay. Penalties you are all aware of. As we have discussed at various times. Hunting for Schedule 1, Part 2 of Schedule 2 outside a sanctuary will also be 3 years to 7 years. But all offenses, hunting offenses inside a sanctuary national park will be 3 years to 7 years. Hunting offense in a core area of a tiger reserve is again 3 to 7 years, but the fine amount is 50,000, which can go up to 2 lakhs. In some cases, we have found in court orders that the magistrate has not even fined the person of the minimum fine, in which case you must point it out. And if it is not less than 10,000, it can be quite a bit. It can be even 1 lakh. So this is something which you can point out through the public prosecutor. So this is now let's look at bail. As I told you earlier, under 51A, the public prosecutor has to be given an opportunity if a person has been accused or convicted. Even if the person has 2-3 pending cases, you can make out a case before the magistrate, and the public prosecutor can seek that an opportunity is provided to oppose the bail. Let us look at some judgments that have come out from courts. Mumtaz is a very good judgment, and when the accused has said that he is quite innocent, the court has said that he has been found with all this material and he was in the business of carrying out wild animals, and even the co-accused cannot be granted bail on conditions of parity, on the ground of parity. So these are some of the things. And it says the applicant was found in the house involved in the activities and therefore he is equally guilty. It cannot be accepted that he is innocent and was inside the house by chance. So he is not entitled to bail. Application is rejected. Another very important judgment which came out, which was upheld by the Supreme Court, also is Suraj Pal, which was a major judgment, and in which the Sessions Court had granted bail, and the court very clearly held that the offence has been alleged to be committed of a tiger, a wild animal specified in Schedule 1 in a national park, and the offence was not so serious and therefore only 2 factors, namely so and so, so and so. So he says that the course adopted by the learned Sessions judge was not in consonance with the guiding principle laid down by the Supreme Court. So the bail granted is hereby cancelled. So these are some judgments. If anybody wants copies of these judgments, I can certainly send them by email and you can keep it in your files and produce it before courts. Opposing a bail application. There was a major case in Karnataka where a public prosecutor approached me and I presented a note based on these following facts or following guidelines contained in a Supreme Court judgment, which is Prashant Kumar Sarkar. Now, how do you oppose a bail? So while granting of bail, the following has to be considered. Whether there is any prima facie reasonable ground to believe that the accused has committed an offence. So you will produce material and the magistrate forms an opinion, prima facie, that the person has committed an offence. What is the nature and gravity of the accusation? You will say that this offence involves minimum period of 3 years extending to 7 years. Wildlife trade is second only to narcotics, etc. So it's a grave offence. Severity of punishment. Danger of the accused absconding or fleeing. This is often the case, and I know how difficult it is for forest officers to trace these people. They will have practically, some people will not have any address. They'll have bogus Aadhaar cards. They will not be found. They will go settle somewhere else, and it will be extremely difficult if the person absconds. The character, behavior, position, and standing of the accused. You may produce relevant material to convince the court that he is not eligible for bail. Likelihood of offence being repeated, common. Same fellows will come in and commit those offences. So you can produce material in your opposition to the bail application. And in this, you have to work with the PP. And if that does not happen, it will be a little difficult. And in some cases, witnesses may be influenced. That's a common thing. And justice being thwarted by grant of bail. Because with great difficulty you have affected and caught the person, waited the whole night and facing all kinds of danger. you have secured the person. And by granting of bail, justice may be thwarted. Now let's quickly go through hunting offences. How do you book? Section 9 is an offence, Section 27 is an offence, 31 is violated, 34 is violated probably, 39(3) is violated, 57 is burden of proof, which I mentioned to you. So the violation sections are these. Please don't put your sections pertaining to definitions, powers, penalties as violation, because it will look, oh, so many sections are violated. No, what you will have to do is, these are specific sections which are violated, read with subsection 16 of section 2, 32, 35, and 51 is penalty, 55 is your power to file a complaint. So always do it in this manner, because only those offenses or sections that are violated, please mention those sections in the violation column. As I said, compounding under 54 in a sanctuary is not permissible. 57, we have discussed how the burden of proof shifts. So I will not go into this. I can share a judgment copy. Wildlife trade offenses, you may end up seizing material like this. And here what happens in case of scheduled animal, I told you part 1, schedule 1 or part 2 of schedule 2, 39(3) will apply, 42, 42A, 48A, 49B, read with the following sections. 49A, which I have mentioned there, is the definition of a scheduled animal. So these are some of the sections that apply. In case 52 can also be included, or it can be read with if there is abatement. If it is schedule 3 and 4, also the following sections apply. 44, as I told you, 48A, 49, 54(4), no compounding if minimum imprisonment is prescribed. Read with the following sections. Now, there is also the Foreign Trade Regulation Act, where wild animals cannot be imported. All forms of wild animals are prohibited items, either for export or import. So that is also something which you can use. This is available. This is, you can keep a copy. And CRPC, let's try to see only a few sections. Complaint. I have said complaint many times, means any allegation made orally or in writing to a magistrate, but does not include a police report. Police report is nothing but a charge sheet. All offences under any other law and Wildlife Act will be investigated and regulated under the CRPC, except where specific provisions overriding the CRPC are mentioned, like in 58, where investigation has to be done by an officer of or above the rank of ACF, etc. Person informed, arrested has to be informed of grounds to offence and his right to bail. 51, be very careful when you're dealing with, when you have arrested a lady or you're going inside a premises where there are ladies inside, because it can lead to, as you are fully aware, lot of allegations, and you have to take all the precautions necessary. For example, you may need to search a lady who is probably in possession of some animal article which she has concealed on her body. You don't have a female staff with you. Now, a lot of women have been recruited in forest departments also, but unfortunately, you don't have a lady officer or a guard or anybody with you. What do you do in such cases? What you must do is get a local school teacher or a primary health center nurse or somebody who can search the lady privately, not in your presence, and that search will also be valid, or a lady doctor or whoever it is. It can't be a male officer searching a woman. This you are aware of, but solutions also have to be found. This you are aware of, that within 24 hours. Case diary, I had mentioned, if that system is not being followed, kindly see a police case diary. Case diary is hugely important. A lot of things can be recorded in the case diary and defense will not be entitled to it. Detention and arrest, we discussed. Cognizable and non-cognizable, we have discussed. Bailable and non-bailable, we have discussed. Complaint and charge sheet, we have discussed. Raid and search, we have discussed. Seizure and forfeiture also we have discussed. These are things which you seize. You should be able to identify which is a fake. Obviously, the one on the right side is a fake because evenly the stripe has been painted, apart from size and other things. And even with the photograph, you can say that it's a fake. Whereas no tiger will have uniform stripe patterns on both sides. The belly, as you go towards the belly, it will become whiter, the size will be bigger. And even if you take your finger and rub it on the skin, all the orange color will come out. There are many ways of identification which you will be aware of. Tusks, a very, very major seizure happened with these tusks. And some national level agency claimed that it was in the front page. But these are fakes, because no elephant tusk, as everybody officer in Tamil Nadu would know, would have a solid thing. It will always have a hollow. Only towards the tip it will be. Simple things. These are visually you can recognize. You don't need a veterinary report or whatever. If you do all these things, I'm pretty certain you will succeed in putting wildlife criminals behind bars. And the book may help you. Kindly read it. I welcome any suggestions that you may have, so that in the next edition I can add if something is missing or whatever. So kindly share your responses. My email ID will be shared by Sanjeev and Lakshmisha, and you can certainly write to me. I'll be happy. So I come to the end. So I've tried to squeeze it in and managed to finish it within the stipulated time. If you have time, I'll be happy to answer questions. Thank you very much. I'm slightly louder. I'm not able to hear, please.
Hi, Praveen, I have a couple of questions.
Yeah.
One is in today's day and age, can a search warrant or a warrant be issued in more, in the available means like a phone or a message or something like that?
No, search warrant issue. Sorry, please come again.
In the form in today's day and age. If an exigency arises, do we have to go through the same procedure?
Yeah.
And format, or can the ACF issue a search warrant in the available means?
See, today you're right. See, the ACF can drop the search warrant in his office and WhatsApp it to the raiding party. And it can be served via WhatsApp to the person, followed by an official copy also. So it is, see, these are things which have to be, each situation will be different. There is no hard and fast rule, but the point is that the courts will try to establish whether due procedure was followed or not. Whether this was some forest officials have recklessly entered some house and tried to ransack the house, or whether due care was taken but a physical copy of the search warrant could not be at hand, but a digital copy was available which was shown to the person whose house was being raided. So these are some of the things which will have to be handled. It is not, but there shouldn't be any fatal errors of not issuing a search warrant at all.
The other question that I had was, we wildlife volunteers, are we covered under our law for our travel or being in the sanctuary?
Sorry, for what? For what wildlife volunteers? Sorry?
We wildlife volunteers, are we covered under our law for our travel or volunteering purposes in the sanctuary?
Yeah. See, actually the Wildlife Act prescribes that any person, public person, has to go to the assistance of the forest officer when his assistance is sought. This is very, very clear under 50 subsection 7. Let me point it out that whenever any person is approached by any of the officers referred to in subsection 1 for assistance in the prevention or detection of an offence or in apprehending persons charged with the violation or for seizure, it shall be the duty of such persons or persons to render such assistance. So therefore, that provides. And it is the duty of every citizen to protect forests, rivers, lakes, and wildlife. This is a constitutional mandate. 3, even to protect and defend public property and to catch a person who has committed a cognizable offense, the public has a right under provisions of CRPC also. So that is called as a citizen's arrest. So therefore, you can get involved, but it would always be important that under 28 of the Wildlife Protection Act, a permit or a permission is obtained from the Chief Wildlife Warden for you to carry out your activity with respect to conservation of forests and wildlife. That would be important. So you can request and permissions are granted and you can secure that permission and operate. So that would be better. And whenever forest officers seek your assistance, you're duty bound to provide that assistance. Yeah. Sorry, I'm not able to hear you.
Just checking if there are any more questions.
Okay. Is somebody speaking? I'm not able to hear.
There is a discussion regarding that ACF being the authorized officer to investigate the complaint.
Yeah.
So I think what he's referring to is probably the notification from the department which says that a ranger is authorized to lay a complaint before the magistrate. So there's some confusion.
Ranger is authorized to
lay a complaint before the magistrate. That's
correct. Let's not get confused. Let me clarify that a ranger is competent to file a complaint. My point is that a ranger is not competent to investigate. He can't be the investigating officer. Investigating officer has to be a person of or above the rank of ACF. Complaint can be even forester. The government is fully empowered to authorize even a forester or a deputy RFO to file a complaint. The person filing the complaint can be different from the person investigating. The restriction under the Wildlife Act is limited to the fact that investigation has to be carried out only by an officer of the rank of ACF and above.
I think that was a confusion here.
So
I think the notification is also clear, sir. So we're talking about laying the complaint before the magistrate.
That is perfectly valid. Complaint can be filed by the ranger, no problem at all.
Officer is added to the witness.
Sorry?
The investigation officer
Ah,
is added to the witness in the case of
added to?
Can be included as a witness. Is it possible? Is it admissible?
Sorry, I'm not clear.
His question is whether the investigating officer can be included in the list of witnesses.
No, the investigating officer will appear before the court. In fact, the investigating officer records the statement of witnesses and he will depose because the accused will summon the investigating officer to the court and cross-examine him. There are two kinds of things. One is cross-examination and examination in chief. The difference is cross-examination is done, as the name suggests, by the opposing party. Examination in chief is if the complainant, the range forest officer, for instance, wants to, has shown the AC witness. He will summon him and subject him to examination in chief, where he will be a prosecution witness. That is possible. But invariably what happens is that the defense will seek and to cross-examine the investigating officer.
Thank you. Does that answer your question? Any more questions? We'll take some time more.
in cases for forest cases
Ah.
or police cases, the remand report is same or different, sir?
Sorry, remand?
Remand report, sir. Remand report.
Ah.
Remand report.
Right.
Is different from the police case or forest case, sir? Same or different, sir?
No, you can use it, but only thing that if you are preparing a remand report, why don't you will have to mention the sections of the Wildlife Act under which you have arrested the person. If you are saying that you want to use the format of the Forest Act for this?
Is there any different remand report for?
No, see, even let me tell you that even if there is no printed or numbered document, these formats can be created on your computer and the relevant section of the Wildlife Protection Act can be mentioned, 51, where there is a power to arrest, and you can seek a remand. So you can prepare these documents, even complaint, the CRPC, as I showed you, said that it can be made orally or in writing. So you can create that format. Ideally, it would be better if you have a printed format specifically for wildlife offenses, because everything, all formats, if it is under the Wildlife Act, it will be better, particularly issued to wildlife ranges, which are now exclusive wildlife ranges. There are across the state.
The point is that you should preferably have your own format for wildlife cases, not as a remand report.
It would always be better when you are prosecuting wildlife cases, having separate documents for Wildlife Act would always be better, because this mixing up can lead to some problems.
I think there's one more.
But let me clarify that these may not be fatal errors. Unlike the ranger investigating, it will not be fatal errors. Some kind of thing can be, it can always be sorted out.
Whether you can include sections from the IPC in a forest case.
No, actually IPC offenses cannot be investigated by forest officers. So while you can mention it, it will have to be taken up. The forest officer can give an information to the police officer stating that certain IPC offenses have been committed, and the police officer can launch his own investigation.
One more question.
Hi, sir. You said regarding the booking of cases in the sanctuary area, when it comes to schedule 1 to 4, any hunting cannot be compounded.
Yes.
So, I'm asking about schedule 1 and 2. In case of schedule 3 and 4, if an animal is being hunted by people, mostly we are dealing with tribals. So we are in a case or we are in a situation where we need to compound them. Is there any other provisions that without being prosecuting them or filing a charge sheet, can there be any other section be invoked?
No, no. If it is a case of hunting by anybody in a sanctuary, the minimum period of offense is prescribed, which is 3 years, as I mentioned, which can extend to 7 years. So, in which case, if you read 54 of the Wildlife Protection Act, if you read subsection 4, provided that no offense for which a minimum period of imprisonment in section 51 shall be compounded. No offense shall be compounded, which means that even if it is schedule 3 and 4 inside a sanctuary or national park, you will have to compulsory, and whether it is a tribal, non-tribal, NGO, non-NGO, whoever it may be, all persons are equal. They will have to be prosecuted in a court of law.
Thank you. The question is that offense is outside a sanctuary or a national park? Maybe an RF or outside a forest area even. So do the same provisions apply?
I'll tell you. I think I mentioned this, I'll repeat it. If it is schedule 1 or part 2 of schedule 2 outside a national park, whether it is in a reserved forest, whether it is in revenue land, private land, or inside a village or inside a town, etc., wherever, including in the headquarters of the forest department, it will have to be prosecuted. But if it is schedule 3 and 4, it is the discretion of the officer to prosecute or compound. Nothing in the law stops the officer from prosecuting a schedule 3 or 4 offense on a private land or in a reserve forest or anywhere outside a sanctuary. The only restriction is that compounding cannot be done of a schedule 3 and 4 if it is inside a sanctuary. The reverse doesn't apply. So if the officer decides that there is a notorious person and he is indulging in some trade and is keeping some wild animal articles in some market in a village or in a town, and he has been caught earlier and fined 10,000 rupees, he is indulged in it again, then he must prosecute. So nothing stops the officer from prosecuting a schedule 3 and 4 offense, but the officer is debarred from compounding an offense on schedule 3 and 4 inside a sanctuary. No compounding can happen. Or let me finally put it, all offenses can be prosecuted except teasing of wild animal in a zoo under 38J, which involves only an offense of 6 months.
Clarification on the same doubt on this extension of it. Actually, you said in section 2, the hunting says that every attempt to do so also. So in sanctuary area, if in case a person is taking some kind of a wire and he is loitering inside, so that also becomes hunting. So that cannot also be compounded, sir.
No. If the officer has come to the conclusion that the person or a group of persons or gang or whatever it is had entered the sanctuary with the sole purpose or with the primary purpose of laying a snare, to hunt, and he has some evidence also to that effect, then if he decides that a hunting case will be taken up against him, he cannot compound. But if he's decided, no, these people have just loitered into the sanctuary, they are not really trying to hunt or something, they unknowingly entered or whatever it is an innocent entry, then they can compound, or sometimes they will just warn and send the people back. So that is also there.
Thank you. One second, there's one more question.
Sure.
The question is, there are a lot of videos on social media which are showing how to catch wildlife or trap wildlife or stuff like that. So the question is, under what section of the law can you take this kind of matter?
See, somebody posts a photograph of hunting on social media. Now the first primary task will be to recognize that person. Either the person was involved in posing with the animal and he is trying to boast and trying to show off on social media, or he may be aware of somebody who has hunted and he may have gone in possession of the photograph and is circulating it on social media so that it goes viral or whatever. So it will have to be investigated in that manner. And if it is established that the person is posing with some killed animal, then his identity will have to be established, and that becomes a piece of evidence. And the person can be prosecuted.
Thanks, Praveen. One more question coming up.
Yeah.
Can you bring in offences under Biodiversity Act also in cases?
Yeah, you can, but yeah, you can invoke the provisions of the Biodiversity Act also. There is no bar, but the only thing is, when the Wildlife Act itself is so comprehensive, and I explained about forest produce, many of these Biodiversity Act cases come with respect to forest produce and so forth, like barks, roots, tubers, etc., or collection, large scale commercial collection of some forest produce. So the Wildlife Act has very stringent offenses, penalties for this. No harm, you can invoke the Biodiversity Act. The member secretary of the State Biodiversity Board will be authorized, and the local wildlife ranger or the ACF may not be empowered by way of a notification under the Biodiversity Act. So that is something which they will have to check out. See, I don't think if the question is addressed because if we add more number of acts and more number of sections, the penalty will increase. That is a misconception. Even if you put only section 9 and in case of a hunting and not put any other section, the person can be convicted for up to 7 years. So it is not as if the case becomes stronger. The case becomes stronger when the quality of evidence is better. The case does not become stronger when more number of sections and more number of laws are added.
Question regarding the option of prosecuting or compounding when an offence occurs in an eco-sensitive zone. So it belongs to the sanctuary. Eco-sensitive zone is kind of part of the sanctuary. So
the same thing applies, Sanjeev, same thing applies, because eco-sensitive zone is outside the sanctuary. Eco-sensitive zone can include private land. And there is a case of hunting of schedule 3 or 4 in the eco-sensitive zone. Now, as I said earlier, it is the prerogative or the discretion of the officer to either prosecute or compound. So it is the prerogative or discretion of the officer to prosecute or compound if it is a schedule 3 or schedule 4 animal outside the sanctuary in the eco-sensitive zone. Eco-sensitive zone, as I said, can be private land also.
As in police, we don't have farm.
Good afternoon, sir. I'm Prabhu, DFO on Wildlife. Thanks for interacting with us and with your clarity and stronghold in legal laws. Really, we got benefit from this interaction. You might have seen a lot of questions from our field staffs. It shows their involvement, and we need in future also such kind of wonderful session. Sure, we'll make a plan, sir. You have to visit here and you have to interact with us. We are waiting for that time. Thanks
you
for joining with us.
Thank you, and I would have loved to be with you, but for a COVID situation that happened at home, and otherwise I would have loved to be with you and interacted further. And I certainly want to visit your sanctuary, and it's an important sanctuary, and it's at the cusp of and forms an important corridor also to other protected areas. And I'm very interested. I'll certainly come once the situation improves. Thank you very much, and I hope that it was of some use to all the officers. Thank you.
Sure, sir. Thank you. Thank you.